William Wagener. We're at the Madera County Courthouse where there's an appellate hearing today. We'll see what happens in this courtroom. Madera County Courthouse appellate hearing of James Pavosky.
Dad filed this one. I filed
Dad
the
was an officer.
same day that I filed.
Thing is, his wife.
April 29? Okay, we're good. That we'll pass that then. Let's do the writ. Albino.
Gina Bradshaw, on behalf of the people.
SCR 0068 appearances for the record.
Gina Bradshaw, on behalf of the people.
Clerk read all of the paperwork that's contained in the file, all of us have done that. We're willing to listen to any arguments that you have. Mr. Fabersky, you can go first.
Yeah, first, a third-party intervener, as usual, on special appearance, one of the people of the state of California in this court of record. In this matter, I will refer to the Constitution has been incorporated by reference at the clerk's transcript, page 150. That's the appellant's statement on appeal. So I am giving notice respectfully to this court, directing the presiding judge, who should also state his name for the record, that a ruling needs to be made on following the Constitution on these matters on appeal.
We're going to follow the Constitution. You don't have to worry about that. We're all here. Judge Oakley, myself, Judge Moffitt, and Judge Fisher.
Okay. And I also want to note, by way of argument, that the justice panel on this case has been changed, which is considered to be very inconsistent and prejudicial, affecting the appellant's rights to a fair appeal. And noting the particulars on this, one of the justices sat directly on a prior related appeals case of the appellant on this. The presiding justice was a trial judge as well on another directly related matter, and also a named defendant in the plaintiff's federal complaint, as well as the female justice has been on this very matter that is before this court on appeal right now, making orders, as well as a named defendant in the federal complaint. As well as, you know, the background of two of the justices being former prosecutors. So, and also the court system in the district attorney's office is named defendants in this federal complaint. So I feel this is extremely prejudicial, and everybody should be recused that's on the panel today. That's one of my arguments. The rest of my arguments have already been submitted in record on appeal, and they stand. And so I will summarize that the conviction and the sentencing should be dismissed by this court.
Thank you, Ms. Bradshaw.
Your Honor, the only addition, in addition to the filings by the respondents and the respondents' brief that people would like to respond to, for the appellant's reply brief, in which he cites, begins on page 8, line 17 and a half, and then there, and subsequent to that, he does state, as far as the California Rules of Court He sticks with 2.100. It's understanding the people, Your Honor, that is, he cites the formats of papers to be filed in trial courts, which does not apply to the appeals level as Madera Local Rules of Court 8.1.1, basically saying that all briefs shall be prepared and filed as provided by California Rules of Court 8.706. Now, Your Honor, I am taking these rules cited from 2006, 2007, and then they're in 2008 when the briefs were originally filed. Now I understand it has been repealed effective January 1, 2009. It's been adopted as a different rule now. But in the 8.706, the format of the briefs should be prepared and followed as to Rule 8.204, subdivision B, B as in boy. And in that section, the form is, this entire format of the appellant's brief is in complete compliance with that format. That which is the understanding of the people at this time. Your Honor, other than that, the people submit as to the formal and written responses that's been submitted to the court at this time, as well as the items that have been already noted and noticed to the appellant at this time as far as the record on appeal.
Here, Roberski, response to that argument?
Well, I stand at the current copy that I have of the CRC is correct in respect to what was cited in the brief.
Thank you. I think we'll take the matter under submission. We'll issue a written opinion.
Thank you.
Okay, let's
And
go back to the...
may I also get the minutes for this? There was a
After
sign.
they're prepared, I'll send you a copy. Mr. Kaza, for the third time, John Kaza. We will call the case, Mr. Kaza's case. This is an appeal that has been
See if it's in the interest of the people.
Very uneventful, huh?
What? I just want to ask you a question. Can I ask you a question? You can stay right there. Why do you think the rule was changed in January to allow people who had already been on this case to be on the appellate?
No. The ruling in which I was stating was just the filing format. He had stated in one of his briefs that essentially the pages needed to be line numbered, the margins needed to be different, the font size needed to be different, the spacing between each line needed to be different. That's what he was saying, oh, the people's brief is the margins are off, the numbers are off,
so
all that stuff.
picking the technicalities, and you were saying no.
And what I'm saying is, yes, effective January 1, 2009, but at the time this was filed, it was clearly way before, because this stuff was filed in December of 2008.
Okay.
The rulings back then, what was the filings of the people was in compliance with what is required for an appeals to be filed. In trial court stuff, there's certain ways that things need to be filed. However, though, when you do an appellate level thing, it's a completely different format in the way it's supposed to be submitted. Down to even like you need to have a cover sheet and the title and caption.
But you didn't address his issue as to the constitutionality of the same judges who had some cross interconnection with this case also sitting on the appeal. You didn't address that. Is there a reason you didn't address that?
Because that is something he just rose just today. There was no notice on that behalf to me, and that is something that's going to be taken up directly with the court. That's something that I have that's not my.
So because it wasn't on the court record, you don't have to deal with it?
No. That's not something that's addressed to me to handle. This is going to be something that he's basically telling the court that I want you to take notice of this. I want you to address this as far as to what you guys are doing. Has nothing to do as far as the appeals. The appeal itself, we need to look at the record and what's happening and make sure that that was in accordance with the law and the Constitution as far as the trial and everything that happened on that. What he's talking about was a whole new issue he completely brought up today, and he's asking the court to notice that one. That's not, he's saying it doesn't have anything to do with the trial itself, of which I'm assigned for the appeal. And like I said, I'm assigned to handling it as far as you follow through the appeal, from the trial aspect.
How long have you been working for the DA's office?
Oh, good question. Wow, I never sat and thought about it. 4 years?
4 years?
4 years maybe about. The thing I'm saying is that if you want to know all the technicalities of it,
Oh, I know.
you can.
But who's pressing
court
charges?
files.
Is it the cop?
No, it's the state of California.
But is the cop pressing charges? You need a real victim
Penal Code 740 is the person who was harmed.
Okay.
Penal Code 740 is
State.
the person who was harmed. Who's pressing
In
charges?
California,
I'm well aware of the procedures. Who's pressing charges? Who's pressing charges? The cop can't.
People's State of California.
He issues a police report, but who's pressing charges?
people of the state of California.
Do you really think, ma'am, Regina, do you really think he did push the cop? I mean, he doesn't look like the kind of a person that goes around pushing cops.
Sir, it's not up to me as my opinion or not. I just put the facts on and.
So
that's what I
you,
do.
but somebody,
Okay.
somebody filed an information
Thank
at some
you.
point.
It's not up to me to decide personally.
Okay.
Yeah.
Well,
I see what you're saying.